Yes,
My lord, it's a prayer for listing a fresh matter for tomorrow, my lord.
after some time, let's see.
Hello.
Any adjournment motion?
Adjournment request from item number 1 to 3. From item number 4 to 9. Any adjournment request?
Please, my lord. With the consent of petitioner, I beg to mention item number 4, my lord.
4.
Yes, my lord.
Yes. Adjournment slip has been circulated with the consent of the other side. January.
Deeply obliged.
3rd February. Any other request? 3rd February.
My lord, it's a prayer for listing a fresh matter for tomorrow, my lord. It's pertains to eviction, my lord. So while the single judge has decided the matter to examine it was directed to the respondent to examine whether the petitioners belong to the reserve forest or not. Basically, that was the direction. But there was no time frame was given, my lord. So we are exposing to the eviction immediately, my lord, at any moment. That's why,
No, for time limit, you could have gone to the court,
my lord,
the same court for review. The same court for review
My
or
lord-
modification of the order. Why
My lord,
appeal?
there are some
You're
other
not- you're-
there are
you're-
some other grounds also, my lord. Apart from
What is
that,
the
my
other-
lord.
What is the other ground?
Other ground is basically they didn't follow the Forest Act, my lord, and the regulation also, my lord. And there are some provisions of rehabilitation
See,
also.
if
The
the-
court didn't consider about
the-
the rehabilitation, my lord.
Just a minute, if the matter has been remanded to the authorities to find out whether you are an encroacher or you are a squatter on the government
Yes, my lord.
reserve forest land, then it's a remand. We are not going to interfere otherwise. If you want a time limit to be given, and otherwise also this bench has decided about 100 petitions. What is the procedure? What is to be done?
My
You
lord.
don't worry about eviction at the moment. You consider about filing a review petition. This can come only, no urgency. This can come only in December.
My lord, maybe tomorrow, my lord.
No.
Because they
Tomorrow
are
they
exposing to eviction at any moment, my lord. Because,
Doesn't matter. No, they can't.
my lord,
This is your apprehension which can't. Once the matter has been remitted to the authorities for consideration, I don't think they would make themselves
my lord,
available to it.
I'm sorry, my lord, after eviction, there will be, the matter will be infractious. Otherwise, no cause of action would be there.
You're not understanding what we are saying.
I'm
or
under-
We are not understanding what you are communicating, trying to communicate to us. See, the matter has been remitted to the authorities to find out, to consider.
I understand, my lord.
So therefore, during that period, without consideration, they're not going to pass any eviction order.
Definitely,
They're
my
not
lord.
going to execute it.
Definitely, my lord.
So in case you want a time limit, you go before the single judge. Or if you want to challenge it on any other ground, that ground, but we don't find it to be urgent to be listed tomorrow. That's what we are trying to tell you. If you're understanding, all right, otherwise take a date or you choose to go before the same judge and file a review or file an application for modification of the order. We can't help you. And as it is,
My lord.
you must have a look at the judgment delivered by us in about 50 of the writ petitions relating to eviction
Yes, my lord.
authored by my brother.
I have looked into it, my lord. And some matters have,
That's all right, no urgency. It
some
is
matters have gone to the Supreme Court also, and their Honorable Supreme Court
You
has,
are of every fact, so why are you mentioning for listing tomorrow?
Honorable Supreme Court has issued the direction for maintaining status quo, my lord, in that regard also.
In respect of possession of those very cases. It's not a general order of status quo.
Well, definitely not general order, my lord.
That's all right. We are not listing it tomorrow. Some other time on its maturity, you take a call. Yes.
Maybe on Monday, my lord, if possible.
And if you want, we can have it listed sometimes in December. Second
Then
week of
then
December.
the matter will be infractious then, my
It
lord.
will not.
My lord.
We have been telling you this. It shall not become in practice. Why don't you go before the same judge, file a review, withdraw this petition?
Fine, my lord, fine. Much obliged.
May I please your lordship, my lord? I have filed a writ petition on 17th, my lord, by,
You have filed a review.
no, my lord. Not filed review, my lord. I have filed the challenging the law itself of 1964 Act of Assam Division and Acquisition, my lord. The law is defunct and impliedly repealed, my lord, after 2013 Act.
So what do you want?
My lord. Now, I want to get it listed, my lord, tomorrow, my lord, very urgent, my lord.
Everything done
Lord.
tomorrow. Some other time you are challenging the very law.
My lord, I
therefore
want
it
some interim prayer is also there, my lord.
it shall come sometimes in December. Give a date.
My lord, it will be, my lord, of no use, my lord, because I have prayer for my lord.
We are afraid we can't allow that prayer. Yes, next. 2nd of December, if that suits you.
No, my lord, I have like. I do not need it in December, my lord, it is useless, my lord, till then everything will be over, my lord.
Law which is in existence since 1964.
Yes.
You say that by tomorrow, if the matter is not heard,
No, my lord, not that, my
heavens
lord.
are going to
My
fall.
lord, your lordship has already heard the matter in 3 other matters and also given some interim protection.
So that will cover you also.
Then my lord, no, my lord, that's why, my lord, I am praying for interim prayer also. That's why, my lord. Otherwise, it may go take time, no problem, my lord. It will
Where is
take
that
time.
order? Where is the interim order in other cases? Show us.
Yes. My lord, the interim order in substance is that subject to outcome, then may proceed, my lord. Kindly see the last, my lord, the paragraph number. Paragraph number, my lord, 14, 15, my lord, 14 and 15, my lord.
No, this is the.
Single judges,
No, that's the law. His lordship is asking to know. Yesterday I mentioned I filed this case under 64 Act. Club. And now I am challenging the 64 Act.
No.
It is an order.
Passed by a learned single judge.
This is under 64 Act. My. And that is also, my lord, no notice was issued, 3(1) violated, 4(2) violated, my lord, everything violated, my lord. And government is offering us, my lord, 1/20th of the market value, man. 1/20th. And my lord, not going under to the 13 Act, going under 64 Act, we have no such provision to give us proper, my lord, protection, proper compensation, my lord. That's why, my lord.
What we can do? Monday at best.
Oblige, your lordship.
One.
Oblige. Monday, my lord.
See, our experience is that all these urgent mentioning, they turn out to be, matter the petitions are dismissed.
My lord, matters of eviction, that's why, my lord.
All right, Monday.
Monday, oblige.
Monday. Yes. 20. Daily list for orders. Item 1.
Mayor, please, Lordships, in this particular matter, we were required to file an objection to the IA which they had filed. There was some difficulty in filing it today. We're filing it within the course of next week, Your Lordships. Perhaps Your Lordship may take up the matter for final disposal in the first week of December, subject to Your Lordship's availability.
Only thing is that now we have all the parameters
What is the decision of the Supreme Court?
pending,
So
No.
but then there is no stay order there.
that's all right. But then why do we vacate this stay?
If your lordship will see the order, the interim order against which I'm asking for a
Let her
clarification,
respond.
there is no stay as such in that order.
If you can give an undertaking that it shall not be for drilling, only for R&D, we are going to vacate. We are going to
In fact, For
clarify.
R&D, it is in fact for R&D.
No, Lordship, that is the strange
The
part.
EC given to us
In the
is
garb
for
of
R&D.
R&D,
In
in
this
the garb of
volume
R&D, you will
saying-
start drilling. See, there is no difficulty. We know that oil is necessary.
Yes, lordship.
We also understand that a balanced approach, a nuanced approach has to be adopted. Now, we can't say no to every developmental work. We understand that.
Right. Yes.
This order was passed sometimes in 2020. And that was kind of that was the response to a blow up of the oil in the DNSP.
Condition
Correct.
only,
That's all right. So therefore, for vacating the stay, let her file her.
Let me
objection.
file. I'll be deeply obliged.
the only condition there was the biodiversity impact assessment report. That is now there,
And
and that report has been accepted by the authorities.
no, accepted to what was the finding of the report is the important question, Your Lordship. They have said that
You
it's a
want
high
the
impact.
matter to be decided today without?
No,
the
no, not
counter-
at all,
No,
Your
no,
Lordship.
without the objection, we are saying no.
No, I'm just praying for a
So
short
therefore,
date.
wait for the.
I will
wait
pray
for-
for a short date only to that aspect, you know.
She has asked for a short date only.
Yes, Your Lordship.
No, I'm just expressing my anxiety also in that regard.
No, Anxiety is of.
Because the EC is of 2020 and this work is
We
now,
understand that.
it's been stalled.
So this R&D, we will require an undertaking from you that it is R&D only.
Only.
For the reason that the matter is pending before Supreme Court. The committee also has been constituted. They are looking at it.
Yes, Lord.
In
The
fact-
constitution of the committee also has been changed.
Correct.
Correct. So Supreme Court has taken a very serious view of the matter.
But no stay order.
We are absolutely conscious of that fact.
As
No
a
stay
fact-
order because there was no reason to pass a stay order. The stay order passed was also not vacated. So therefore, the stay continues. And you want it to be vacated, you don't want the objection to be filed.
No, it will let it
You
be.
see, your urgency is not going to deflect the course of justice. We understand that.
Definitely.
Notwithstanding the fact that you are one of the Navratna companies of the country of this
It's a
country.
responsible PSU and it will do as per the directions of the
Recognize
government
that.
only. It's a
Recognize
R&D, it's
that.
a R&D.
The country is run on oil. We understand that. But there is something else. You know, the Supreme Court says in many matters and in different ways, but one line which is very striking, it says that if it is not checked today, there shall be no tomorrow. With this kind of exposition by Supreme Court, you think that we will vacate the stay in a jiffy?
No, no, no. Therefore, this big petition, you lost.
Therefore, you don't
I was never expecting that.
Don't
Therefore,
ask-
everything is
don't
great.
ask the
Right?
bench to unnecessarily, waste its lung power and tell you something. Huh? Here. An interlocutory application has been filed by the respondents for vacating the stay order granted. Wide order dated
7/12/2020.
7/12/2020. MS Rakhi, learned advocate for the petitioner, submits that the objection to such petition shall shortly be filed and that the matter be taken only thereafter. Let such an objection petition be positively be filed
Within
on
next week.
on or before the next date, re-notify it. We keep it, what time?
As per your.
First week of January. You want it in first week of December? First week of December?
Yes, sure. No difficulty.
4th of December.
Both of them. Yes.
Obliged, Your Lordship.
Deeply obliged.
Item 2.
Yes.
May it please, your lordship. Impugn order is at page 90, my lord.
Yes.
Paragraph 2, my lord, will give us the gist of the case, my lord. If I may read. The case of the,
Don't wait for the court to look at you.
Yes.
We are flipping the pages. You keep on arguing. We are multitaskers. Right. We see this, we also write and we hear you. Don't wait. Yes.
the case of the petitioner herein is that the subdivisional officer Karimganj Land Acquisition Branch had initiated steps for acquisition of 15 bighas, 17 kathas of land, which included the land of the petitioners for construction of the departmental.
Mr. Bhattakur,
Yes.
this is the way you would argue an appeal. You tell us where is the fault line?
Yes.
Why do you want an intervention? Facts in short. If you read, if you're not prepared, come tomorrow.
Then if I may take your lordship to page 94, my lord.
Page 94. Yes. These observations are only meant to, help you hone up your skills. You are a young counsel. If you start reading, what purpose? Then we will also read. We'll ask you to sit down. We'll read. Yes.
Paragraph 11, my lord, actually page 95. Paragraph
Paragraph
11.
11 of the judgment.
Yes, ma'am.
Yes.
Now, let this court deal with second point for determination.
So what are the facts?
Facts are that, my lord, a land acquisition proceeding was initiated in 1981 for a requirement of the forest department, my lord. And then a value was assessed and accordingly, the value was paid by forest department to the revenue department. Thereafter, my lord, due to certain inadvertencies of revenue department, they had not published the final notification. That we have admitted, my lord. Then, my lord, these petitioners found.
Do you stop at that? That is not correct. That's not a correct exposition of fact. Now that you did not come out with a notification, the entire process lapsed.
Yes.
That is what the judge says.
Without the fault of the
And there
forest
is,
department.
the other point also has been determined. So nothing can be done.
And
We are absolutely in agreement with the judgment.
most importantly, my lord,
Arey, Pale, you answer, Pale, cross this hurdle.
Yes.
Has it lapsed or not?
it has lapsed, my lord.
So therefore, where is the question of your agitating it now?
Two reasons, my lord.
Look
One,
at this.
Yes.
The last part of the judgment says that the said exercise be carried out within a period of 6 months from the date of certified copy. And otherwise also the other side, the landowners, they also have not shown their bona fides. So that
Yes.
they will show their bona fide provided the acquisition process is pending, or it has taken its effect. It has not taken its effect. You have taken away the land and you have constructed a building. How will you explain this paradoxical situation? It is a conundrum, Mr. Counsel. Can't argue it like this. No, this requires the court can come down heavily on the department. And you're trying to whip a dead horse now. Carry out the construction. I think you would do better by following the directives in paragraph 12. Take a call. If you're being led by any senior, please consult him and then ask us to interfere. Otherwise, we will put our seal of approval on this. And then we will add few lines also that the thing is lapsed, which is sub silentio here. We'll make it very explicit.
I'll,
You followed?
yes, my lord. I'll see.
Therefore, you are on a very big wicket. Try and find out some other thing. Plain reading of the judgment, you will not be able to do anything. Tell us something more about the facts. We can. Because you have already constructed a building.
Yes.
We will not allow it to be demolished. But what is to be done? Then you pay the compensation. And be done with it. You can't have both. You will not pay compensation and your acquisition is not complete. Can it be done? Try and understand. You want us to write all this? You want us to write all this?
I may be given some time, my lord.
What
I'll-
time? This is
see.
what I tried. I mean, the way you started the argument, I knew that you would get stuck up somewhere. Huh? This is the experience of this court. No, court has remained there for 22 years. What do you want?
The matter may be fixed on another day, my lord. I'll
As
see.
prayed for on behalf of the appellant, re-notify. Whom are you
One,
representing?
two, three, Lordship, private respondents. Land
Private
owners.
respondents. What right do you have?
Lordship, we have Patians in our names, and we have Pattas.
The land, the normal, fallout of the judgment is that the land is still in your possession,
No, Lordship, land already
has been
Lordship,
taken.
impliedly, Lordship, in our possession, but they have taken away and they have constructed building.
They have
Lordship.
constructed the building and you have not been paid anything.
No, some amount I have paid.
The enhanced
thereafter it
compensation
lapsed,
which was
Lordship.
already allowed.
Lordship,
But the single judge says that compensation also should not have been paid because you have not been able to demonstrate that you are the landowner.
we are the landowners, Lordship. It was.
You are the landowner.
Lordship.
Have you filed an appeal against this?
No,
There
Lord.
are 2 points decided, one against him, one against you.
No, we were directed to file representation and prove the document, to produce.
Have you
the
done
doc-
that?
Yes, Lordship,
And
representation.
you have not challenged this.
No, Lordship.
If you have not challenged this, then you are nobody. You are, what is it called? You don't exist for us here.
Lordship, there is a direction given to DC to see the documents produced by the landowners.
Abhi, see, look at this. How many times should I explain?
Lordship,
You are a persona non grata so far as this petition is concerned.
Lordship.
Absolutely. Unless you challenge this finding.
Lordship.
Have you challenged this finding?
No, Lord.
Then who advises you? You please advise the client appropriately, no?
No.
Because the second point of determination goes against you straight away.
Lord.
Correct? So you have been asked to go and file representation. Unless you challenge this, how do we acknowledge you as existing on record?
Lord.
You have to challenge this, no?
Lordship.
Take a call, both of you.
Lordship. Obliged, Lordship.
If the matter is to be litigated, it must be litigated scientifically.
Lordship.
We say as jointly prayed for.
Lordship.
As jointly prayed for, re-notify January.
Obliged. Lordship.
Obliged.
7 January.
Do you understand? If they come out with new requisition and notification and revive the old thing, still you don't have a right to be paid. They can even initiate a recovery proceeding against you. Judgment is bad. Therefore, more than them, you are required. They are having their building. You are not going to dispossess the government department. So more than him, you are required to challenge this judgment. We have not followed deadpan expression, not followed. Anyway, we can't be advisors. No, we have only told you, take a call.
Item number 3.
Yes, yes, sir.
My lord, a short point which is involved in this case is whether the disciplinary authority,
Did you go through Ibrahim? De novo inquiry. Ibrahim, you saw.
my lord,
Union of India versus, I don't know which.
I am relying on Vijay Shankar.
No. You have to find out. I mean, that day only I told you, no? Union of India versus Muhammad Ibrahim.
Okay. Sorry, my
Chaudhary,
lord.
Mr. Chaudhary, there are two things here.
Yes,
The power vested in a disciplinary authority. This is not High Court. I mean, High Court has not remanded. The power vested in disciplinary authority by virtue of Section 9 of the Act is appreciation and passing an order. Now, the only point that you can agitate is that on your representation, it should not have been remanded. That's one. And two, without any complaint on the inquiry officer, he should not have been changed.
exactly.
But now, when the disciplinary authority finds that you are not satisfied, otherwise also the listed witnesses, the witnesses who were examined were not listed, no opportunity of cross-examination. The only way out was to return. was to
Yes,
remand.
from that stage. And by the same
It
inquiry
begins
officer.
from the first stage, no?
My lord.
By another inquiry officer, but who are you to say that, well, this inquiry officer only shall conduct my proceeding?
No, my lord,
I
Supreme
mean,
Court has,
therefore I said, read Ibrahim.
Supreme Court had said that. my lord.
Where is that?
Yes.
That is, if you're relying on R.K. Dev of this,
Here they,
K.R. Dev of
Ah.
this court,
ah.
then that is with respect to harassment.
No, my
But
lord.
here the issue is
There is
different.
one more judgment, my lord.
Hmm.
Please have this 2014-10 SCC 589. Yes. 2014-10 SCC 589. My lord,
Yeah, just a minute.
my
Let's see-
grievance,
Let's see the judgment first.
yes,
Your grievance we have followed. That day only you argued very
Yes.
ably and we have understood it.
but somehow it went
Therefore-
out of my mind regarding that Ibrahim's case, my lord, to be
I
honest.
think Ibrahim is the judgment,
Yes.
which we have followed a number of times in several of the judgments questioning the remand.
Yes.
Remand from which stage? I
Please come
don't-
to para 26 at page 603, my lord.
Para?
Para 26 at 603. After referring to care depth, it can be seen from the above that normal rule is that there can be only one inquiry. This court has also recognized the possibility of a further inquiry in certain circumstances enumerated therein. The decision, however, makes it clear that the fact that report submitted by the inquiry authority is not acceptable to the disciplinary authority, it is not a ground for completely setting aside the inquiry report and ordering a second inquiry. The scheme of Rule 8 of the Discipline Appeal Rule and Rule 15 of the CCA rule are similar. Therefore, principles laid down in Dev's case, in our opinion, would squarely apply to the case in hand. Therefore, it becomes necessary for us to examine the legality of the impugned order in the light of the law laid down in Dev's case, whether further inquiry is really warranted in the facts of this case. Well, I'll pause here for a moment, my lord. What I would like to submit for your lordship's kind consideration is,
Yes, sir.
Lord, in a given case, there could be a situation where further inquiry may be necessary. But the issue is whether, my lord, you will change the inquiry officer, you will order a de novo inquiry. Is that within the competence of the disciplinary authority under Rule 9?
That's right. De novo inquiry and a second inquiry, these are two different concepts.
Yes.
The charge is not being changed.
No, my lord,
From the stage of
whatever
examination-
infirmities was noticed by either at the instance of
Is-
disciplinary authority or the delinquent,
No,
whosoever may
the
have
stage of
pointed out.
vulnerability, from there it has to be.
Yes,
done.
from that stage.
So therefore, it begins from the cross, the inquiry officer has examined witnesses.
Has not
which were
cross-examined.
Listed, which were not listed.
Ah.
And therefore you did not get an opportunity or you did not avail the opportunity of cross-examination because you're not prepared. So this stage comes right after the service of charge.
Of course. No,
So
I'm
that-
not on that.
So you-
Therefore, it
you-
is not
you
my
are- therefore
submission
you-
that there cannot be a further inquiry.
Therefore, let us not say further inquiry because it creates confusion. De novo inquiry or inquiry from that stage,
Yes.
remand. Further inquiry is something else. Further means what? Further here has no
No,
application.
well, as in this case, the
Further
allegation,
here, sir, it has no application. We are not dealing with 173(8) of CRPC. Therefore, no further.
173(8).
173(8) of CRPC. So we are not doing it. Further is an expression which should allow it to remain there.
Normally, yes.
So now, therefore, the only grievance of yours is that the inquiry officer has been changed.
Yes.
But why are you bothered?
No, Milord, I'm bothered.
Why?
It has to be, because there are certain things, Milord, I need not be prejudiced. The fact that this is not permissible, that's the end of the matter.
That's right. So injuria sine damnum sine injuria principle, you're pressing it here. But we are finding it difficult to accept.
No, Milord, my humble submission is, I complain that there are some infirmities in the inquiry. Therefore, redo it from that
So
stage by
now,
the same inquiry
How does
officer.
how does it affect you adversely if another inquiry officer, I mean, the
No.
question is, don't take it otherwise.
Yes.
The assumption is that you are happy with the inquiry officer.
No, it's not something like that, Milord. There are judgments where the Honorable
where-
Supreme
where
Court
did-
has also said
Hmm.
that merely because it is not to the liking of the disciplinary authority, you
Correct,
cannot
correct,
change an
correct.
inquiry officer.
Here, the disciplinary authority relied on your representation.
Yes,
So your
Hmm.
representation, you don't deny.
yes.
So only the officer has been changed.
So my humble submission is, Milord, let,
show us
let the earlier inquiry officer do from that stage and let it be done, Milord.
That
And
would
this
again-
whole thing has
that
to
would
be
be again-
interfered with.
That would be.
Otherwise,
again-
Milord, serious prejudice will be caused to
No,
me
no,
because
why? Where is the prejudice being caused?
because the second inquiry officer is not even envisaged in the scheme of Rule 9 of the rules.
But
Huh?
where is the bar?
Then, Milord, it will go on. Then tomorrow they will like it do the third
No,
time
no,
also.
Not at all.
No, please have Rule 9, Milord, Assam rule,
Hmm.
which is parametria to Rule 15.
But you have no objection to remand.
But
You have no objection to the remand.
naturally, Milord, my prayer is, Milord, this order of punishment, etc., has to be set aside. Matter has to be remanded to the inquiry officer to start the inquiry from this stage as was earlier noticed. Rule 9, Milord.
Which is discipline and appeal.
ये पूरा civil service rules का compilation है तो.
Sub Rule 5 of Rule 9.
Just read it aloud.
Yes. The disciplinary authority may nominate any person to present the case in support of the charges before the authority inquiring into the charges. Government servant may present his case with the assistance of any other government servant approved by the disciplinary authority. Oh, sorry, I'm sorry, Milord. 6. The inquiry authority shall, in the course of inquiry, consider such documentary evidence and take such oral evidence as may be relevant or material in the regard to the charges. The government servant shall be entitled to cross-examine the witnesses examined in support of the charges and give evidence in person and to adduce documentary and oral evidence in his defense. The person presenting the case in support of the charges shall be entitled to cross-examination, cross-examine the government servant and witnesses examined in his defense. If the inquiring authority declines to examine any witness or to admit any document in evidence on the ground that is evidence or such document is not relevant to material, it shall record his reasons in writing. At the conclusion of the inquiry authority shall prepare a report of the inquiry, recording his findings on each of the charges together with the reasons therefore. So, my lord, it does not contain any provision which entitles, similar parameter provision is Rule 15 of the CCA rule, which was interpreted by the Supreme Court in K.R. Dev's case, where the Honorable Supreme Court clearly said that it does not envisage, second inquiry. Basically, I am on the aspect of the second inquiry. Even K.R. Dev, my lord, if your lordships would kindly have K.R. Dev for a moment. In fact, in the judgment, this para is quoted, my lord. Para 12 of K.R. Dev is at para 25.
Para 24.
No, para 25 in my lord Bijay Shankar's case where para 12 relevant.
we
Yes,
are,
quoted
we have,
at
Yeah,
page
they-
602, Miller.
we have KR Dev before.
Yes, it seems to us that Rule 15 on the face of it really provides for one inquiry. But it may be possible that if in a particular case, there has been no proper inquiry because some serious defects has crept into the inquiry or some important witnesses were not available at the time of inquiry or were not examined for some other reason, disciplinary authority may ask the inquiry officer to record further evidence. But there is no provision in Rule 15 for completely setting aside previous inquiry on the ground that the report of the inquiry officer or officers does not appeal to the disciplinary authority. Disciplinary authority has enough powers to
Yes,
reconsider.
Mr. Speaker.
Yes.
Now, we are not very satisfied, but
Hmm.
you answer some query. You answer our query.
Lordship,
Now,
what I
whether-
understood from my learned senior colleague,
No,
Lord,
no. Here's
just
the question
because the
first.
inquiry officer.
Here's the question first.
Lordship.
Now, remand is all right under the circumstance. The order has been, the disciplinary authority remands the matter, single judge upholds it. Now, he says that while remanding, the inquiry officer was changed. Now, his argument is that this change of inquiry officer partakes of the character, partakes of the uh, assessment that this is a second inquiry. It is not the same.
Just because the inquiry officer has been.
That is what he says. That is what, I mean, we are not getting
Lordship, what
satisfied.
happens if the inquiry officer retires in between?
No. What retires in between?
Suppose an inquiry has been entrusted to an inquiry officer. If in the meantime he retires, Lordship, one second inquiry officer will come into.
You have given us something to think. Yes, Mr. Chaudhary.
Milord, I think my learned friend is not properly advised, Milord. Inquiry officer does the inquiry officer for the purpose of inquiry, he continues. There is a state inquiry officer who is served beyond retirement. Milord, there is a state inquiry officer concept. Normally, inquiries in respect of the state government employees are conducted, the inquiry is committed by the state inquiry officer. They don't retire, Milord. There's got nothing.
Even when he retires, he continues.
Yes, yes. The state inquiry officers are appointed post-retirement.
Yeah.
No, my lord, where is the difficulty in doing?
Now, his example is if he dies.
That is the example, Lord.
If he dies.
If it dies, yes. If it becomes, my lord, I think in legal parlance, we can also say incapacitated on account of so
Yes.
many reasons.
Yes, that
Oh,
that
those
is
are
the
exceptions.
Softer way of handling.
those are
It is
exceptions.
dying Incapacity. Or
Incapacity.
he resigns.
Yes.
Or he resigned. But that is not the case here.
Yes.
The officer may got transfer also.
Hey.
He was working against.
Oh.
If
Now, the one line argument, capsule argument of Mr. Chaudhary is that by doing this, you have converted into a second proceeding and not the same.
In my understanding, if Lordship comes to the page 113, Lordship,
Of?
the impugn order, Lordship. That is 12 January 2023. Page 113, Lordship.
113.
113, if Lordship comes to the third paragraph.
Hmm.
Whereas therefore, for the end of justice, previous paragraph, Lordship, it was his request.
Hmm.
Whereas in the
His
written
request was
request,
for demand. His request was not for change.
yes.
Whereas for the ends of.
Whereas therefore, for the end of justice, the governor of Assam considers it necessary to initiate the de novo inquiry in the matter from the stage of recording evidence, ensuring strict adherence to the proper procedure as per the Assam Service and Discipline Appeal Laws 1964.
Hmm.
So earlier part remains.
No, they have followed it. Whereas therefore, by the ends of justice, the governor of Assam can to institute a de novo inquiry.
Yes.
All right. But where is this decision to change?
Next paragraph, Lordship. Now the governor of Assam, in exercise of power conferred by Rule 9495 of the Assam Service and Discipline Law 1964, hereby appoints Sri Ambika Kumar Saloy, Superintending Engineer, Nalbari Circle Irrigation, Nalbari as Inquiry Officer, and Sri so-and-so, Assistant Executive Engineer.
Why have you changed?
That specific instruction I have to take, Lordship, but probably the reason was one of the inquiry officer has already submitted his report.
Even if you suggest that
Yeah.
later after instruction, can that be imported into the order which is under challenge? which is that case Mohinder Singh Gill.
Lordship. No, only issue remains, Lordship.
There could be good reason.
The only issue remains, Lordship, whether appointment of a subsequent inquiry officer would give the inquiry the color of a second inquiry.
You're right.
That is the only reason, Lord. And in my humble understanding, no. There may be situations when inquiry officer can be changed. There are certain numbers of examples, Lord, several examples. In several situations, we change inquiry officer, we change presenting officer. That will not convert the inquiry into a second inquiry. No. It is the same inquiry. And that is one point, Lordship.
No, no, the charge remains the same. Can you find out some,
Ibrahim, I've got it just now, Milord. Mohammed Ibrahim, it is one page order, Milord.
does it say something?
Milord, I was just reading, when the matter was listed for admission, Milord, the citation is 2004-10 SCC 87.
The memory may, I mean,
Yes.
but this is what we have been using.
The procedure in the case in order of, I think, Milord, here, I think a fresh proceeding was sought to
Oh,
be initiated
it was-
after a long delay of 17 years.
Uh-huh. This is something else.
We are unable to
Jordan,
execute the-
heavily loaded with reason.
Yes. That really matter.
But the matter was listed
Actually, my lord, the person who adduced evidence before the preliminary inquiry, they were examined, my lord. That was one of the reasons. Therefore, we disposed started press proceeding and conclude. My lord, my humble submission would be, my lord, going by CARDEB and other authorities, in an appropriate case, there could be a de novo inquiry or a further inquiry, whatever nomenclature we may use. But it cannot partake the character of a second inquiry. Now, what has been done at page 113 is nothing but a second inquiry. By that too, by another inquiry officer. If my complaint was that you have not permitted me this and that, then we should start from that stage. It's not a judicial proceeding that the presiding officer has been transferred. Therefore, it has to be done by somebody else. So that way, my lord, CARDEB's judgment is a clear authority for the proposition that normally there cannot be a second inquiry.
Difficulty is that we are not getting.
And my lord, if your lordship would kindly come to page 113 for a moment.
The test of prejudice element is still weighing very heavily with us for interfering.
No, my lord.
Was this a case where
No, my lord.
injurious sin and damnum sin injurious
No,
not
my
to
lord.
be present?
No, my lord, I am relying upon Antule's case and Baseswar Nath, my lord. If there is a violation of fundamental right, I need not plead and establish
No, this is
prejudice.
fundamental right to be tried, to be.
No, no, it's a fundamental
domestically
right,
proceeded against
fundamental
the
right
officer.
in the sense, my lord, I have been denied equal protection of the procedure established by law.
That is stretching it too far.
No, my lord, kindly have a look at page 113. Look at that paragraph. Now the governor of Assam, in exercise of the power conferred by Rule 9 and 4.
Mr. Chaudhary, then what is weighing with us is if we are not satisfied, we are not fully satisfied with the prejudice clause, then why do we interfere with, this is a view of a judge. This could be a view. We are not, this is not a perverse view.
No,
This
my
is,
lord.
this is the, this
No,
is
my lord.
the,
No, my
this
lord,
is the
what-
way we deal in appeal when we have.
No, certainly, my lord. If the view is not, I mean,
Tractor.
merely because another view is possible, that is not a ground to interfere in a writ appeal. That is there, my lord. But the question is whether the view which the learned single judge has taken
Perverse.
is a plausible view.
It's not a perverse view, it is a plausible view. That they have changed it. The officer, the inquiry
No, my
officer
lord,
was,
kindly
the inquiry
see-
officer did not know how to conduct it.
No, my lord, kindly see, they're taking help of rule 9, 4 and 5. Where does rule 9, 4 and 5 enter?
Where does rule 9, 4 and 5 prohibit it?
Yes, of course, my lord, it does. The language suggests that there will be one inquiry. Kindly see, my lord. And not only that, look at the later portion. Appoints Sri Ambika Kumar Saloy, so and so, so and
Can
so.
you give us now, we are almost concluded in our mind what we are going to do.
Yes.
But then if you can show any judgment which says that the inquiry officer cannot be changed, we might consider. Otherwise, logically, we are not able to
Principal,
persuade.
give me one more opportunity. Let me
Yes,
see
you
if
will
I
give.
find out any authority.
Take them. You have heard Sri K. Chaudhary, learned senior advocate for the appellant, and Mr. Naik for the respondent. The short question posed before us is whether a disciplinary authority is entitled to remand the matter to the inquiry officer on his finding that the principle of natural justice were not observed while conducting the proceedings, and if so, from which stage the remand would be operative. First up, in the present case, the representation, in the present case, a representation was filed by the appellant before the inquiry officer, before the disciplinary authority, that the inquiry officer had examined witnesses who were not listed, and the proceedee / appellant did not have any opportunity of cross-examining the aforementioned witnesses. First up, it appears that the disciplinary authority in this instance, without recording any finding and taking resort to the provisions contained in section 9 of the, which is it, Assam? Assam Service Disciplinary and Appeal Rules 1964, correct nomenclature, remanded the matter, directing for the inquiry to be conducted by a new inquiry officer. Mr. Chaudhary, learned senior advocate, though admits that such power vests with the disciplinary authority, but it can only be done by the disciplinary authority if an assessment on his own is made and not merely on the representation of the proceeding. First up, the other contention on behalf of the appellant is that in case the inquiry officer is changed, then it becomes a second inquiry, which is not permissible. The remand has to be made from the stage where the vulnerability appears. First up, the flashpoint here is from the stage where witnesses were examined who were not listed and the appellant did not have the opportunity to cross-examine. Would that then authorize the disciplinary authority to, while remanding the matter, change the composition of the inquiry, change the inquiry officer? And if such a decision is taken, would it not amount, would it not partake? Would such order not partake the character of directing for a de novo fresh inquiry akin to second inquiry, which in turn could be termed as second inquiry? First, This court prima facie is of the view that in the event of principle of natural justice not having been followed, the matter was correctly remanded, which remand was upheld by the learned single judge. But whether it was permissible for the inquiry officer to be changed and inquiry, full stop, and with capital A. And if the inquiry officer was changed, what prejudice has been caused to the appellant? Full stop. Mr. Chaudhary, learned senior advocate, submits that he shall advance further arguments with respect to this aspect of the matter on the next date. Re-notify.
Deeply.
Re-notify on, give it in
Any date, my lord.
January.
Yes, sir.
It would be an interesting question, but a novel question. We have not come across such a
My lord,
situation.
somewhere Lordship has
Yeah,
used
they
this
will-
second, Lordship may also use the word after this slash press.
Second,
all-
fresh, de novo, everything we will say. Second slash fresh.
January.
That prejudice element is holding us back.
I'll try to address your Lordships on that prejudice
Yes.
part.
Item. For hearing, item 5 to 7.
May it please your lordship.
Yes, Mr. Borgohain.
But before I commence, I would like to apprise this honorable court that my lord, item number 7. Item number 7. I'm a bit handicapped because I'm not carrying, I could not carry the brief with me. Item number 7. That is the
We'll hear you on some other date. When you are here in Guwahati.
My lord. Because my friend is there, I have given the compilation also, brief one only.
Give us the compilation here and you argue on the next date. We have no difficulty in hearing you virtually.
My lord, I would love to appear physically only because for some matter, that's why I have to come back to Delhi, my lord.
Compilation, your friend is not here.
Oh, it has been filed, my lord.
No, it is not. No. Your friend is not here. Number 2. Number 2, we would like to hear you when you are in physical form before us.
My lord.
Again,
My lord.
let all these matters be listed for final hearing. Final hearing on. We give you a date in January.
My lord.
Sometimes
After Bihu, my lord. After Bihu.
After Bihu, so February first week.
My lord.
3rd of February.
My lord.
And ask your friend to supply the compilation so that in case we get time, we can go through it.
My lord.
All right.
Obliged.
But your friend is not to be seen here.
My lord. My friend, Mr. Sarkar, was supposed to be there.
Supposed to be, but he is not here.
I'm so sorry, my lord. Sorry.
All right.
Obliged.
Item number 8.
How many cases do you argue a day, Mr. Chaudhary? How many cases? There was a judge in Patna High Court who stopped an advocate, a senior advocate, a top class senior advocate from appearing in more than 2 cases before his court. I'm not going to do that.
No.
Because the list will fail.
Possible do that today, my lord, because the other matter I have not come prepared. There's one more matter, next item.
How that otherwise also we would not have it. We can't keep on hearing one counsel for the day.
My lord, the short point involved in this case is,
Yes.
as a deputationist, whether I'll lose my seniority in my earlier department.
What happened?
Lord, the facts are like this.
Just state the facts in
2-3
short.
dates, my lord.
Yes.
On 4/2/99,
4/2/1999.
yes, the appellant was deputed, my lord, from irrigation department to PNRD department. That is DRDA.
Oh, just a minute. From irrigation to Panchayati Raj.
Punjab, Panchayat and Rural Development Department.
Panchayat and RD, right?
Basically, I was placed in a DRDA, my lord.
Yes.
DRDA.
No, no, right from the beginning, you were at DRDA.
No, my lord. I was initially, working as agricultural extension officer in irrigation department.
That's right.
Yes.
After the.
And
No,
my
irrigation-
service,
Your original service is from irrigation department.
yes, my lord.
Then.
My lord, if your lordship should kindly come to the page C list of. the- okay.
Let us first
Yes,
state the
yes,
facts.
yes, yes. Then, my lord, prior to that, my lord, on 15/11/97.
No.
Okay.
Let us hear.
Yes,
from
yes.
4 to 99, you were deputed from irrigation to Panchayat and Rural Development Department.
Yes.
In the department only.
No, my lord, it's a different department.
No, in the department of Panchayat and Rural
Yes,
Development.
Yes, yes.
See, there is difference in DRDA and Panchayat. DRDA comes within Panchayat.
No, in Assam, my lord, Panchayat and Rural Development is a one composite department.
One composite department and DRDA is an adjunct.
Yeah, adjunct.
Okay. Okay. District Rural Development Authority.
District Rural Development, DRDA.
It's a body created under.
My lord, these are under the schemes formulated by the central government.
It is not a body created under any statute.
No,
No, it's a registered society,
society.
registered society.
Surprising, with the same name, these are bodies in the neighboring state as a body created under a statute.
No, in the state of Assam, it's not.
This is an agency.
Yes, adjunct.
There it is authority.
Yes.
Okay.
Then on, my lord, pursuant to order dated 4/2/99, I joined on, I was appointed as Assistant Project Officer Agriculture on deputation. On 25/2/99. First order was 4/2/25/99. I was appointed as Assistant Project Officer Agriculture on deputation.
Agriculture.
Yes, agriculture. My lord, 12/3/99, I joined. Then, my lord, on 25/9/21 to 2001, PNRD department requested irrigation department to furnish NOC for my permanent absorption in PNRD department. Pursuant thereto on 29/9/21, the NOC was provided. Then, my lord, on 27/1/2005, I was purportedly repatriated to, my lord, irrigation department.
To a parent department.
Yes. Then I assailed that order in WPC number 1109 of 2005.
What is it? WPC number?
1109.
2005.
Yes.
Let us see the order passed here.
Yes, my lord. Page 90.
Nervous trouble. Makes me feel nervous.
No, 90 petition. My lord, order is at page 96.
Yes.
My lord, initially there was a stay order, my lord.
Yes.
That order lordships will get at page number 94.
This order was kept in abeyance.
Yes.
The repatriation order.
Yes. Then, my lord, it was finally disposed of at page 95. And the operative portion is at 96. Mr. Das, learned Standing Council BTC has produced a copy of the order passed by this.
You are
court.
reading at which page, Mr.
Page
Das?
96, my lord.
Page 96, Mr. Das.
Yes, Mr. Das, learned Standing Council BTC has produced the copy of the order dated 2/5/2007 passed by this court in WPC number so and so, in which under similar circumstances and noticing the aforesaid OM dated 19/7/97, it has been held that a deputationist cannot continue in the borrowing department and that on the strength of the said office memorandum cannot claim absorption in the borrowing department. However, it was provided in the order that it will be open to the petitioner, for the petitioner to file an application for regular absorption in the borrowing department. Considering the matter in its entirety, this writ petition is disposed of in terms of the order dated 2/5/2007 passed in WPC.
So the stay order was vacated and the repatriation was sustained with the liberty to you to approach.
Yes, I approached my lord.
Hmm.
Based on that, my lord, the matter was placed before the cabinet. Cabinet gave an approval. Then on my lord, the person,
Cabinet gave an approval.
yes. Then eventually, my lord, if your lordship would kindly come to page 107, my lord, the cabinet memorandum. Extract from minutes of the cabinet meeting held on so and so. Permanent absorption of services of C. Soiful Alam, Assistant Project Officer, Agri, DRDA Headquarters, Nagaon, under establishment of the Commissioner, Panchayat and Rural Development Assam, approved.
A permanent absorption under the establishment approved.
Yes,
So you were approved
yes. Then copy.
from which date?
Now come to page 114.
This is on 2016.
Yes, 16. In the meantime, I continued in Millard DRD. Sorry, yes, DNRD, PNRD. Page 114 is the order, Millard, 12th of September 2016.
Page 114.
Yes. On his services being placed at the disposal of the Panchayat.
Yes.
On his services being placed at the disposal of the Panchayat and Rural Development Department by the Irrigation Department, Government of Assam, Soiful Alam, Assistant Project Officer, Agri, DRDA Headquarters, Nagaon is hereby permanently absorbed against the vacant sanctioned post of Deputy Director Training, which was created by order dated so and retained permanently by order dated so under the establishment of the Commissioner, Panchayat and Rural Development Assam in the scale of pay on rupees so with great pay of so as per ROP rule, with effect
So
from the
Therefore, you are
catch is here.
questioning the date.
date of joining Panchayat Department is my lord 4/2/99. Now, this issued with the approval of the cabinet in relaxation of etc. etc. Then, my lord, and my lord, one clarification was sought for by the Office of the Accountant General, which was given at page 121, my lord. If your lordship would kindly come to page 121.
121.
Yes. In order to put it, we move terror kora dilo. Now, Panchayat and Rural Development Department is Millard writing to the same department from the Commissioner to the Secretary. With reference to the subject cited above, I am to furnish the report relating to point number 3 contained in AG's letter dated so and so. The name of the officer holding the post of Deputy Director Training under establishment of Commissionerate Panchayat and Rural Development Assam, with effect from 13/3/19 to 39/16 may kindly be treated as nil, as earlier incumbent, namely Sri Intazul Monir, the then Deputy Director Training, retired on 28/2/99 from his service. And since then, the post of the Deputy Director was lying vacant in this commissioner. Hence, the matter of creation of supernumerary post with effect from 13/3/99 to accommodate Soiful Alam does not arise. So there is a post. So earlier there was a suggestion for creation of a supernumerary post. The government says no. There is already a post, the incumbent has retired, there is no requirement of
No, the government is writing against you here.
Milord.
The government is writing against you.
Yes, yes.
The government
But
says that
partly
says
in my
because
favor.
this period, this is nil.
Huh.
So therefore, this, you cannot be treated that.
No, I'll come to that later part, Milord. No, Milord, there was an internal communication between the department as to where to accommodate me. Now, they were saying, now there is a requirement of a supernumerary post. It is in that context, this letter was written whereby it was said, there is no requirement of creating a
That's
supernumerary
right.
post.
So therefore, the reason why you were not given this effect of absorption from 13/3/1999,
Huh.
but only from 2016.
16.
When
No,
you were
their
post-
case is, will give you only from the date of cabinet.
But these are two government departments. You don't lose out on pension.
I'm losing out.
How come?
If lordship clarifies that, end of the matter.
How come? Because that's also a government department.
I kindly see the impugn order, my lord.
No, but that's a government department. No.
Yes,
You're not from any private agency.
yes.
So therefore, this
And my lord, deputation is with my consent, but it is a transfer.
Hmm.
Let them clarify.
No,
That is my
was-
only
that was-
grievance.
That was not the issue before the learned single judge.
No, please come
Yes,
to
what do you have
150.
to say?
No, come to 151.
No. Does he lose out on pension because he was in the government department?
You know, he will not lose the pension, but his question is that from who is
Tell me
that
one-
his seniority will be
We
counted.
have followed. Don't repeat the argument.
Yes,
You're appearing for whom?
from the state.
Mr. Kumar,
Yes,
you're additional AG.
yes.
Now, we want to know from you that he has been absorbed in a different department.
Yes.
Initially, he was not private or something. He was in a government department. He was in irrigation department.
Yes.
So therefore, for all practical purposes, absorption here, I don't know why he wants absorption. He does not want to go to that place, go to that department. He wants to continue with the DA, but then he shall not lose on pension. Only difficulty is that you say that against that post, that will remain nil. So therefore, but nil or whatever. So it will be counted from the date he joined service.
It is not,
You give a clarification.
Your Lordship.
Don't argue unnecessarily.
Lordship.
You give a clarification.
Your Lordship, dispute regarding counting of seniority, not pension, Your Lordship, before the single term. And Your Lordship.
Mr. Kumar, that's not what we want. If you argue like this, we will not be very happy. You have to tell us. We are asking you a question. What is the issue? Please don't remind us. Correct? You're always entitled to argue the way you want to, but then this is not quenching our queries. आपसे मैं केवल इतना पूछ रहा हूँ कि you take instructions and tell us that this absorption, then he will not challenge it, I'm sure. Then we don't enter, whether he challenges or not, we don't enter into it. Because it's a interdepartmental transfer, not intra.
Yes.
It is inter or interdepartmental transfer. So if he doesn't lose on pension, what difference does it make? He will remain there from 2016. That is what he wants. He did not want to go back to his parent department. Give one line answer and we close this case.
Yes.
Your Lordship, there.
And then look at the I mean, this borders on impudence.
Yes.
But yes, your argument borders on impudence. When we are asking you politely that this is the fallout and you should tell us, you're saying the issue was seniority and the issue was not pension. Are we asking you this? Don't we understand this?
I understand it. I understanding your
So therefore,
question, Your Lordship.
please don't come with a predisposed mind that this is the argument that you have to make. You have to modulate your argument on the basis of what we are asking you.
Yes, definitely.
Correct. So prima facie, this did not strike us when the matter was being argued. We thought that this absorption, like other provincialization or for that matter anything, it goes back to the date and that date becomes relevant. Here it is a government transfer, deputation, absorption is not the concept which should have been brought here.
Lordship, so far as pension part is concerned, I will have to take instruction. I will take instruction.
Take instructions.
I will take instruction.
Take instructions.
Clarify that, Your Lordship.
I'm sure if even if he presses it, we'll dismiss it in one line.
No, my lord, the effect of the interim order which was assailed before the learned single judges, I joined only in 2016. My earlier service is wiped out.
Ah, that is the.
Exactly.
Make a clarification, the
Yes.
appeal, we don't say anything. We just clarify the order of the learned single judge, don't pass, we don't pass any order.
Yes, definitely.
As if my earlier service is wiped out.
See, the issue is here is pension only, not seniority. That's a supernumerary post. For the absence of any supernumerary post, you absorb him on that particular post which became back.
Yes.
I understand.
And the moment I
So the
retired, it
question
goes.
is that with this order, it has the potential of, wiping out his earlier service, then he comes under a new pension scheme. What are you talking? Is he questioning seniority?
Lordship, I'll take instruction.
Mr. Kumar, this answer should have come in the first instance.
Well, a similar dispute arose when BSF personnel came to Delhi police. Then where there's earlier seniority was not counted.
Take down.
Service, sorry.
We have heard Mr. Chaudhary, Mr. Ken Chaudhary, learned senior advocate for the appellant, and Mr.
K. Kumar, you.
Kumar.
K.
K, what is your full name?
K for.
Kumud Kumar. you.
Mr. Kumud Kaur, learned additional advocate general for the respondents. This appeal is directed against the judgment dated 4/6/2024, passed by a learned single judge of this court, affirmed the decision of the respondents of the absorption of the appellant in the Department of Irrigation, in the Department of Panchayat and Rural Development from the date when his services were said to have been absorbed on the post of Director Training under the DRDA, which was in the year 2016. Full stop. It has been urged on behalf of the appellant that this could be read as an absorption from 2016, thereby wiping out his service before that. Full stop. The appellant joined the irrigation department, but in the year 1999 he was deputed to Panchayat and Rural Development Department. Full stop. Later, the appellant was sought to be repatriated to his parent department, but on his challenge, such repatriation was stayed for a while. But ultimately, the repatriation order was sustained, giving liberty to the appellant to approach the authorities and seek his absorption in the irrigation department. The appellant complied, made a representation on which a decision was taken by the cabinet that he is regularized, he is absorbed in the irrigation department. For the reason that no post was vacant, for the appellant to be accommodated, the order of absorption was passed in the year 2016 when the appellant was posted in DRDA and the post had fallen vacant. The contention of the appellant is that treating his absorption from 2016 would be prejudicial to him But in case it is found that this absorption was only an interdepartmental absorption without impinging on his pensionary benefits later, comma, the date would not be relevant. First off, Mr. Kumar, learned additional AG, shall take instructions in the matter and get back to this court for further consideration.
Deeply obliged.
February.
Obliged.
5th of February, 5-2. Item number 9.
Well, some other date, Miller.
Yes, February, as prayed for on behalf of, you are for the,
I'm for the
who appears for the appellants?
state has filed the appeal.
Mr.
State's appeal.
Mr. Borpujari,
My lord, in pursuance to my lord's order, you are required to file a written submission
you
along
do
with.
file, but the question is that we will not allow only him to argue today.
My lord,
So we are granting time on his account.
no, my lord, they have filed it today. I am required to file it. I am seeking some
Do
order.
whatever, we are not, he is
My
taking
lord,
time.
my lord, my lord.
As prayed for on behalf of the respondent, re-notify February.
10 February.
In the meantime, Mr. Borpujari, learned advocate for the appellant, shall file necessary affidavit in case so deemed necessary.
Miller, sometimes in January, Miller, they're retiree pensioners.
Ocha pensioners, January, last January, after Bihu.
28th January.
Deeply obliged.
I'm so obliged.
This thing, about it.
Item 10.
Yes. Yes,
May it please, sir.
yes.
My lord, this refusal is filed, my lord, against the judgment and order dated 19/7/2024, my lord. Passed in OA 251 by the Lanet Central Administrative Tribunal, my lord. Whereby, my lord, the respondent was giving antedated promotion, my lord, from 2013, my lord. My lord, the respondent, my lord, was working, my lord, as superintending engineer on an ad hoc basis, my lord. One, my lord, he was considered for regular promotion, my lord, in 2015, my lord.
Another cap. Yes.
My lord, when he
Shiv,
was,
just a minute.
But-
Shiv Kumar Sharma and another versus Union of India, was it not specific to the facts of that case? Every time there can't be an upgradation.
Lordship,
Every
Lordship,
time there can't be an upgradation. Are you,
Yes,
we have
I-
jumped 5 stages,
Lordship,
5 stages from where he started his argument.
Lordship.
What do you have to say?
Lordship, in Shiv Kumar Sharma, it was specifically stated this matter was dealt with. And that in that judgment, it was,
So was it not specific for that situation? But can it happen? You are very good. You are suddenly raised to outstanding. Outstanding is given only on special, on your special performance as a very, very good officer. You lost out for
Lord-
10 years,
Lordship.
right? You may be the topper of your batch. You are the person, no?
Yes, Lordship.
You may be the topper of your batch. We don't have any complaints about that. But, over the process, 40 persons, were promoted 10 years before. Now
No.
you are being given promotion from back day
No, Lordship.
only on consideration of your ACR or APAR after upgrading it. Now, can it be done now?
No, Lordship. Problem is,
And where, how others were not heard?
no,
The
Lordship.
tribunal was absolutely unjustified.
I'm coming to that, Lordship. Petitioner, the respondent was promoted earlier, Lordship, on ad hoc basis.
We have followed that.
Lordship.
You were promoted on ad hoc basis, but in regular promotion, you lost out.
Yes, Lordship.
So therefore, in Shiv Kumar Sharma, this was the starting point. for
Para
this-
3 of Shiv Kumar
This
Sharma.
was the starting point. We are aware of Shiv Kumar Sharma.
Lord.
it was the starting point where it said that, since an officer has shouldered the same responsibility and therefore he should not be made junior. But does that apply in your case?
Yes, Lord.
The tribunal, mechanically applied that principle here without realizing that 10 years had passed by and so many promotions had taken place.
Lordship.
So where was the gradation? How it was it to be done? What was that time? What was the assessment of the DPC that time? And ultimately you got promoted.
Yes, I got
So,
promoted,
but why should it be backdated?
but Lordship, they are receiving pay band, Lordship, E9.
That's right. You
And
can
I'm-
also get E9 provided
But-
you don't retire now.
I will retire in November,
So,
Lordship.
but what do we do? This order is bad, no? And therefore the order was stayed.
And Lordship stayed on the basis that 40 people were not made part-
You think that's an easy thing to do? You forgo your seniority, we will ask them to consider.
No, that.
Forgo your seniority, we will ask them to consider.
No, Lordship.
Take instructions from your client.
Lordship.
You give an undertaking that you forgo your seniority, they will have no difficulty. Then also you will have to seek instruction. Seek instructions.
Lordship.
Seniority is the problem, no?
My lord,
But otherwise you are promoting him, he gets the band.
my lord.
Not my lord, take instructions. You can't concede on behalf of the state.
Hmm.
You have to take instructions.
Yeah.
So if you forgo your seniority, we can ask them to consider. We can't ask them to promote you to that post
Lord.
from that day. You forgo your seniority, you forgo all your past, enhancement in pay. We will allow that. Take instruction. Again. Let me not give an introduction to this in my order because it would be loaded against you.
Lordship.
So today we only adjourned.
Lordship.
After some arguments, the matter is being adjourned for further hearing on February.
3rd of February, 3-2.
Deeply overlooked.
List of. For orders, item 1.
Yes.
May it please, lordship. On a very small point, I have filed this review petition.
Yes.
There is a notification 29/1/2023
Hmm.
on the basis of which the department has issued the impugned notices.
Hmm.
It is the notices page 85 and 83. These notices were issued on the
The
under.
cases were decided on the same day.
Yes, lordship.
Is that your case?
Yes. So
And,
on the same day that notification of 2023 was set aside.
Hmm.
It was declared that since it was issued before the coming of the new 2013 rules.
Hmm.
So this notification is not integral and the government is directed to issue fresh notification. So
Tell us whether that can be a ground for review.
any steps taken on the basis of that notification. Lordship, that is.
Yes.
It's taking the character of an appeal, it's a review,
No, don't advance the stock arguments, mister.
my lords.
It is not taking the character of an appeal. He is not saying anything on facts. He is not saying anything.
But
He is saying, just a minute, he is saying that the reasons which weighed with the single judge and the appellate court was the notification of 2003, which gave Forest Department sweeping powers over stone crushers. On the same day when this writ appeal was decided, there was another appeal
Yes.
where this entire notification was, set aside.
Yes,
Right?
yes.
So therefore, this was not a fact which could have been placed before the judge. And now, under the say if there would have been some time hiatus, we could have understood. But there is no hiatus of time. It's on the same day.
My lords, as if I have understood correctly, court was very correct that we don't have jurisdiction to regulate the stone crushers. but still the stone remained, still is a minor mineral which is
No,
regulated.
no,
by-
therefore whether this review is maintainable or not.
My lord. His contention is this, that since the entire edifice.
His contention is what we,
Yes, yes.
translated it to you.
Yes, but what has happened, the contention that, no, you cannot regulate stone crusher, that is good, that is well founded. But the other thing remains that stone is still a product which we can regulate.
Stone is a building material, it's a forest produce, but this notification of 2003,
That
which was the
very,
basis.
yes, we cannot, it was discussed, deliberated.
Get ready,
about,
we
it
will,
is set aside.
we will see what is to be done.
Right. Otherwise, Lordship, court was very
Yeah,
correct.
this is
It was
for
set
admission.
aside.
We admit this application. Take note. The review petitioner. Was the the review petitioner had preferred a writ petition before the High Court by WPC number 5052 of 2022. Challenging the decision of the respondents in imposing compounded penalties to the two, compounded penalties for carrying crushed stone, bracket boulders broken into smaller pieces, the contention of the review petitioner before the learned single judge was that the stones were crushed after those were purchased, after the boulders were purchased, and that it was not a mining produce. The seizure by the Forest Department was based on 2003 notification giving wide powers to the department over stone crushers, which was not permissible. The writ petition was dismissed and the action of the Forest Department was sustained. The appeal preferred by the review petitioner was also dismissed. On the same day, in another appeal, in WA number 304 of 2024, the notification of 2003, which was the basis for the decision of the learned single judge and the appellate court, was set aside, meaning thereby that it did not exist, greatly curbing the powers of the Forest Department to deal with crushed stones. The contention of the petitioner is that the division bench sustaining the dismissal of the writ petition did not have the occasion to consider another judgment of coordinate bench decided on the same day. With the setting aside of 2003 notification, the petitioner contends that the penalties and other coercive steps have become illegal and without the authority of law. The learned counsel for the state shall respond to the aforementioned submission on the next date. Re-notify also. Sometimes in February.
My lord, sometimes can it be preponed, my lord? Can it be preponed, my lords? Because the contention he's bringing is now, it's somehow restraining us, my lords. the stone crushers, stone vehicles,
January.
these dumpers.
All right. Yes, next.
Obliged.
29 January. Item number 2.
May I please, Your Lordship, my Lord?
Yes, Mr. Fuken.
My Lord, it's a review against judgment by which, my Lord, the extension and the re-extension which was given to respondent number 3 was rejected, my Lord. Though it was heard on maintainability, observations were given, my Lord, and the on 18th July 2018, my Lord, office memorandum, which is the very basis of my case. And my Lord, the office memorandum is applied when the extensions were given. So it's an admitted case on the part of the state government.
Mr. Fuken, that was the ground taken by the court to dismiss your PIL.
My Lord,
These are only, I mean, these are no statutory guidelines. These are only, kind of directives to be administrative instructions. But then once appointment has been made, he would not go warranto. I don't think you have a right.
my Lord, what I beg to submit that two aspects, similar three aspects rather. My Lord, first is that the office memorandum clearly said that the renewal can be given only for 1 year, my Lord. And even if it's
This was made coterminous with the life of the government.
yes, my Lord. So that's a clear, my Lord, misreading on the part, my Lord, of the Honorable Court. I
No,
would
this
respectfully
OM
submit.
has not at all been taken into account.
It has
Otherwise,
not.
other factors also would have been discussed, whether the officer was outstanding, whether there was any
My
reason
lord.
for engagement,
My
whether
lord.
it lowered the morale of other officers.
My
It
lord.
was, he was prone to abusing his powers, so on and so forth, adverse comments on him. There are many things which
My lord.
would have been,
And
which would
there's
have
in
been
fact
taken
a
into account.
subsequent
But all
document
this
which we have.
all this need not come in the public domain, Mr. Fuken.
My Lord,
The
what I'm
question is
saying,
this,
my Lord,
the employer knows who can best serve his interest.
my
Now,
Lord.
unless there are other people, but you are an activist, of course, writ of quo warranto can be flagged by anybody. That law we are aware of. But in
Well-
this case, unless you're able to show that because of his engagement or his, extension as a principal chief conservator of forests, the forest rules and regulations were bypassed and things happened the way in which it should not have. How can you maintain this petition?
My Lord, may come to page 54 of my review petition, Miller. This is an
No, but
order.
this is, but again, before that, Mr. Fukin, whether it would amount to a rehearing of the matter, good, bad, indifferent.
My Lord, may have
You could have
page-
challenged this order before the superior forum.
I could have, but Milord, this document came to my knowledge subsequently. Of course, it's a subsequent document, Milord, 29th of May 2025, Milord, where this officer was found guilty by the Ministry of
Doesn't
Environment
make,
and
it
Forest.
doesn't make any difference. You had already made that statement. He was facing charges.
My Lord, he was facing charges, but now not only
This is,
has the Ministry of Environment, the regional office of MOEFCC asked the state government, my Lord, to take action, considering the seriousness, and these are words used in the communication, considering the seriousness, it has asked for action taken report to be submitted every month, my Lord. My Lord, that's one aspect. The other aspect, my Lord, is how can you consider, my Lord, for even a moment, my Lord, that this person has an outstanding record? A, my Lord. B, my Lord, what has happened? There's another very serious violation of the office memorandum, my Lord, which I wish to bring to your Lordship's attention, because if your Lordship sees the para 1 of the judgment, my Lord, which I've sought
Mr.
review.
Fukan, do we need to remind you again that this is rehearing of the matter?
No, my Lord, I'll just point out one thing I've already pointed out, my Lord, this document where the regional office of the MOEFCC himself has taken note of the seriousness, my Lord, that your Lordship will find at
Page
54, my Lord.
Yeah, 1 second, let me just go through the order. But the court took note of the complaint against him of violation of wildlife laws and other things. Now, this was only a culmination. So therefore, it would be the same, it has a link with the facts which were considered by the learned single judge. It's not something new.
What the
I
Honorable
don't
Court
think
said,
you have a case, but in a different forum.
what the Honorable Court said, with respect, at paragraph 33, is that none of the allegations are made out, my lord. Now, my lord, it is something that they have to show. My lord, notice was not issued, no response was called for from them. So, my lord, how do the petitioner now actually apprise this Honorable Court? What is the current status of these proceedings? My lord, may note that this document which I have produced, my lord, with my review petition at page 54, my lord, starts at page 52, my lord.
I would not like to get it. No, we have not issued notice. This is for the first time. But if you don't want to, we don't want to. Very well, we will ask from the state. We are not issuing notice to the private party. I mean, the state means not the person concerned. You must have implemented him.
Yes,
appears?
he's impleted. He's impleted, my lord.
Who appears?
Number
For
3,
the
my lord,
state. Who appears for respond number
is
1?
on the last date, my lord.
Prima facie, we are not inclined,
PK
Mr. Fuken.
Sharma. PK
But then
Sharma.
let the other side also be here to know what is being charged against them.
Yes, my lord, at least because if your lordship sees paragraph 1 of the judgment of which I have sought review, this was heard on maintainability, but ultimately, my lord, with respect, the Honorable Court goes into details, my lord, and rejects, my lord, and the office memorandum has been violated, my lord, on 3 fronts very clearly, in my submission.
I don't think engagement of retire. It has been decided. I don't think we will even ask.
So, my lord, one aspect has not been taken note of, my lord.
Just a minute.
Yes, the 1 year term, my lord, that was a ground which I specifically took, my lord, but is not addressed in the judgment.
Mr. Fukan, which is this letter you were referring to?
My lord, page 54 of my review petition.
Page 54.
Well, it starts at 52. I'm sorry, my lord.
Right.
This is
29,525.
my lord.
Okay.
And your lordship will just come to the concluding paragraph,
It's all right. It's all right.
middle of page 53, my lord.
But it's something else to that.
The last 2 paragraphs take note of, my lord, the seriousness of the issue.
But we would remind you, we would take you to paragraph 34 of the judge.
My
Why
lord.
do we entertain this review
Paragraph 34.
of the judgment thought to be reviewed?
My lord, personal grudge, my lord, this was, my lord, never argued by them, and I
Now,
could
how
have
would it
shown
be
the
argued?
material.
This was inferred by the court.
Well, it was inferred by the court, but I never had the chance to even rebut all this, my lord, and I would
Again,
have
the
shown
counsel for the
in my
counsel,
review
Mr.
petition.
Fuken has appeared on behalf of the petitioner. There is no appearance on behalf of the respondent state. Let this matter come up for consideration again. January.
29-1.
Well, may I
Item
request for a short subject to convenience because it's coterminous with the term of the government, my lord. So therefore,
All right. Yeah, the government would not be, the government would not go out, by January. Elections have to be held. Huh? It is some kind of vendetta, Mr. Fuken, on behalf of your client.
no, my lord, not at all, my lord, not at all. Because he whatever.
Nonetheless, we would be hearing you whether it is a re-hearing or not.
But just
the
to
state
dispel
also
that notion, if I had vendetta, my lord, I would not have produced these documents. I produced all these documents, my lord, and the court took note, but
All
without,
right, here on some other day.
I could have addressed. Yes,
Let the state
obliged.
be.
Deeply
January,
obliged.
last one, January.
29-1.
Deeply
Item
obliged.
3.
No, this. I don't. Yes,
May I please your lordship? Review petition against the judgment and order, your lordship. Then your lordship will kindly peruse page 16, para 28, your lordship.
is 16 para 28.
My lord. May I read it? Then the applicant said that the subsequently the applicant has collected an appointment order of the applicant dated 16/3/2001 under memo number so and so working as assistant teacher at stipendary pay rupees 1,800 per month in Gorbitar Mukta LP school against the post created by
Stipendiary teacher.
my lord. Gov order so and so and allotted by number so and so dated 2000.
May not do. Yes, what do you have to say?
Lordship, this teacher was appointed by the managing committee, school managing committee. And school managing committee has no power to appoint a person against the sanction post. On that basis, SCBTC has director.
That is a wrong
Rejected.
assumption. Managing committee in venture schools or schools which were not taken up by the government, taken over by the government, managing committees were the committees which had the power to appoint. But unless these posts are sanctioned or done something, but he has brought to the notice of this court that which he did not have in the beginning, the post otherwise had become stipendiary at the behest of the government. So therefore, he claims that it was not an illegal appointment, but only an irregular appointment. And this document was not there before the court.
Yes, Lordship.
Take instructions, get back to us on the next date. Okay, the learned counsel for so is present. It presses this review petition. So the counsel for the state seeks some time to take instructions before addressing this. We notify ourselves.
29-1.
Obliged.